I've been away from the FLRA for a few months, but I know that representation matters are always among the matters given the highest priority within the agency's responsibilities.
Which side are you on? Which side are you on?
Ernest DuBester is the former chair of the Federal Labor Relations Authority. That is the equivalent body in the federal labor relations sector to the National Labor Relations Board for private sector workers. He was nominated 3 times by 3 different presidents, and his final nomination, he was not confirmed in the Senate. So he is no longer part of the Federal Labor Relations Authority, but continues to speak to federal workers in particular and other organizations as they are interested in talking to him. And so we're really glad to have on Ernie DuBester. Welcome to the program.
Thank you, Jake. It's great to be with you, and good to be with your listening audience.
I appreciate it. I really do appreciate your time. I know that you're a very busy person, and so I wanted to talk to you about some of the just in general. I think it's worth us going into an overview of federal labor relations, because there are a lot of differences between the private sector and the federal sector. But then maybe a good introduction to that will be if you could explain to the listeners what it means that you were not reconfirmed to another term on the FLRA. What does that absence, it's not even like it's that it's you personally were not confirmed, right? It's that there's an empty seat on the FLRA. And so what does that mean for federal workers? What are the real ramifications of that?
So let me start with just kind of a broader general context. I have the brief pleasure to be listening to your prior conversations that have brought back reflections on my professional life and career. And just so your audience understands the context from which I speak, in addition to just my age and length of service and experience in labor management relations. So I've worked under all 3 of the federal labor management laws, collective bargaining laws, starting with the one that oversees the private sector, and that's the National Labor Relations Board. I've also worked, and I think you were discussing this briefly, I also have worked for many years under the other law, the oldest federal collective bargaining law, which happens to just govern the transportation sector, railroads and airlines. And that is the most unique of the laws. And then, of course, I spent many years working in the federal sector. And as you pointed out, there are significant differences. A lot of people generally say that the federal statute, which is the newest of the 3 laws, is modeled loosely on the National Labor Relations Act, and that the Federal Labor Relations Authority, as you said, is modeled on the National Labor Relations Board. That's very generally true in some meaningful respects. But as you also suggest, there are also some practically significant and meaningful distinctions. And I would just say briefly, going back to when the federal statute was enacted in the late 70s during the Carter administration, that was because the discussion was mostly around what I would call a public policy debate over what I call the unique attributes of the public sector generally and the federal sector specifically. So what are they? What's the most important one? Well, let's start with scope of bargaining. In the federal sector, the scope of bargaining is significantly narrower than the private sector. Number one, there's no bargaining over any matter that's covered by a uniform federal law or regulation. The best examples would be wages and benefits. In the private sector, as you know, wages and benefits tend to be the two primary issues of negotiation, and are usually the two issues that create labor management strife, if you will, and disruption. In the federal sector, though, they're not bargainable. So the narrow scope of bargaining is meaningful for that reason. An additional reason is in the federal statute, and I have it here. If those of you who have ever seen me before, you know I always have the federal statute with me. Here it is, if you can see it at all. I have it with me today. But the federal statute has a very specific, fairly detailed management rights provision. And that gives very broad authority to the management side to exercise those rights in a pretty unrestricted way, with a couple of meaningful exceptions. The statute allows unions to negotiate procedures that will be used for implementing any kind of changes that are based on a management's exercise of its rights. And then secondly, the union has a right to negotiate appropriate arrangements for federal employees who are adversely affected by these proposed changes, and devise arrangements that will, if you will, lessen, target, and mitigate the harsher effects. So that narrower bargaining is a big difference. Now, having said that, I would say to your audience, particularly those of you who are union officials or stewards or just employees, the right to bargain in the federal statute is still very, very meaningful. There are a lot of things that can be done and discussed, and moreover, the principle that's reflected in the federal statute is identical at in the private sector, which is mainly that workers and their union representatives have a say at what goes on in the workplace. And so that's very, very meaningful.
Mm-hmm.
And
Right.
so then in addition, what I would say is in the federal sector, as probably most of your listening audience knows, under the federal statute, unions and management, but unions don't have the right to resolve differences or impasses in bargaining, if you will, through the use of economic weapons. There's no right to strike.
Mm.
Now,
Right.
instead, there's a unique provision in the statute to provide the basis on which collective bargaining impasses can be resolved. And that's with an entity for which there is no counterpart in the private sector or the transportation sector, called the Federal Service Impasses Panel. And the Federal Service Impasses Panel under the statute has very, very broad authority to decide when an impasse is brought to them, how the matter is going to be resolved. Different impasses panels, often depending on the particular administration in the White House, have chosen different methods. But basically, the two ways to go are, obviously, you can go through something like an arbitral process, or you can go, as the current panel's gone, and as it went during the early years of my tenure, through a process that involves mediation first and puts an emphasis on the parties themselves trying to resolve their dispute voluntarily. And that's a process I always favor. Number one, that's what collective bargaining is all about. It's about the parties, and hopefully taking on not only their rights, but their obligations and responsibilities to address any kind of issues that arise in the workplace, and hopefully to come to an understanding that more than is often the case, seemingly the case, that they have a more mutual interest in the agency and its mission, and how resolving their differences or addressing their differences more proactively can benefit not only the performance, the work performance of the agency, but also the service provided to the public consistent with the mission of the particular agency having that dispute. And then the other significant difference I'll just mention, and particularly meaningful for your audience who work in the federal sector, and I appreciate you, and especially those who happen to be on the union side. Under the federal statute, there's no right, as there is in the private sector, in transportation sector, to what we call union security. What do we mean? That's the ability of unions to support their representational activities by tendering dues and fees from their union members. There is no right to that in the federal statute. That is huge. Again, in the private sector, that's the way in which unions are able to support their existence and provide the services and exercise the responsibilities that they have to their membership. But what is there in the federal statute instead? In the federal statute, as an alternative to that, they have the concept of official time. And under that, unions are entitled to give their representatives, their officials, time off, if you will, but official time to engage in representational activities, such as collective bargaining, such as processing grievances and going through the grievance arbitration process. It doesn't extend to non-representational activities that are solely in the union's interest, so it would be argued, such as things like lobbying activities. But official time is key, and even under the statute, and even though that must be provided to the unions, and if an agency refuses to do so, it is subject to liability for that. But even so, that amount of official time must be negotiated between the union and management. They have a right to negotiate over the time that will be allowed. So that answers, maybe longer than you needed, but that answers kind of, or addresses the first part of your question. Do you want me to pause for a minute, or do you want me to go on?
No. Well, if talking about, the narrow scope of bargaining within the FLRA, I have been, over the last month or so, I've been really trying to dig in and learn more myself. I'm taking on more and more union responsibilities on my job, and so I'm trying to be better educated about the statute, because in my capacity, as a radio host for union radio program, as the Labor Council president, I actually deal as much with the NLRA as I would the statute, but because everybody else deals with the NLRA, I've just absorbed a lot of that by osmosis, and I really have been kind of less educated about the federal statute. And one of the things that this was said in in this book that I was reading about the statute, that and you mentioned that unions can bargain over like the implementation of management rights, but unions are not allowed to encroach on management rights insofar as negotiating or putting forward a proposal to not do a thing, right? And so the example that the most extreme example that this book gave was the example of changing job duties of, a bargaining unit that included both electricians and plumbers, and the management saying, you know what, I want the plumber to do electrician work and the electrician to do plumber work. They're going to be, this new job title is going to be called plumtricians, and I want to do this. And apparently, according to this author, the union cannot put forward a proposal to say, don't do that. That's crazy. That's bonkers. Don't create plumtricians. Apparently, the union can't do that. They can only bargain over the implementation. And so saying okay, look, if a plumber's going to be doing electrical work, they need to have the proper training, and this is exactly how that's going to happen. But that's the only thing that they can bargain over. Firstly, is that right? I think it is. Is that right? And then if it is, what is the reason that in your view that the scope of bargaining is so narrowly prescribed in the federal sector?
Well, first, technically what you said, if you take it to its extreme, it is correct. But I have to make one very significant qualification. And for, quite frankly, people like yourself, since you identified your own life and responsibilities as they may develop, but others, particularly, again, if you're in the unions, but I would say the same thing to my counterparts from management and the agency side. You said implementation. I think of that more as procedures, and those are certainly bargainable. But impact is the other part. We call it impact and implementation. And the impact part involves the right to provide proposals for appropriate arrangements. And that's for employees that are adversely affected. And what can we do to protect them? So what would I say? So I would say several things. The first thing I would say, which is going to sound to people like kumbaya around the campfire, but it's not. That's not the way I mean it. I like people to be nice to one another. That's why I got into the business. I like people. But it's in your tough, hard self-interest and hopefully joint interest, why I think it's so important for union reps and their agency counterparts to develop a relationship and be willing to talk to one another. And I mean even outside the collective bargaining responsibility. When most people think about their responsibilities as an agency labor relations person or a union rep, they think, all right, well, every 3 years we have a term agreement comes to an end and let's get together. That's a mistake, in my opinion. There's a reason why both should want to be constantly engaged with one another. And the union reps, yourselves perhaps coming forward, should always be there reminding management that you're part of the system. You're a legitimate part of the system. And you have an opportunity to help employees face some changes like this, which are obviously going to produce anxiety, and remind the employees that you're active on their behalf. But again, agencies should have an interest in talking to you too. And if you have a relationship, to address a situation like you said. So what would I do of a more formal nature in that situation? Well, the first thing the agency has to do is they have an obligation to provide notice, and it needs to be specific about what they're contemplating, why, and who's going to be effective, who's going to be affected. So what does the union then have both a right and an obligation to do in response? Well, at some point you're going to have to make, and within a reasonable period, make a request to bargain over it. But the first thing that I would do, and I would always say this, is I would request information. You can make a general request for information about the notice of change and try to help that formulate how you want to handle the situation with respect to bargaining, and then down the road what proposals. But information requests, and they're obligated under the statute too. So you can make a general information request in the context of, say, this notice of change about this new unbelievable job classification. You could also make a statutory request for information. And quite frankly, if the agency doesn't comply, then you might have a basis down the road for an unfair labor practice. And the agency is now in jeopardy, depending on the outcome of that, of having to undo its desired change. And depending on how long it takes, perhaps be facing a status quo ante remedy, costs, back pay, and if attorneys are involved, they often are, aren't they? Attorneys' fees. So again, what I would say is if you have a collective bargaining relationship, try to avoid all these delays, try to avoid these costs, and hopefully get in front of it and sit down and chat. I would also ask for a briefing. I would ask to be briefed by the agency on their proposed change. And then in addition to that, I would ask and request, either informally, depending on your relationship, or formally as part of your bargaining request, to have the employees who are going to be affected by this proposed change in job classification, have them briefed directly by the agency with the union president. So for starters, I would say, don't overlook, procedures are important too. And they really can have an effect on not only the workplace, the employees affected, and the bargaining process, but it's appropriate arrangements and the impact part of the bargaining part of it that I think is particularly meaningful. And if I'm a union rep, the law around appropriate arrangement proposals is now pretty deep. It goes back over 40 years. I would have a list of appropriate arrangement kinds of proposals that have been found appropriate, negotiable by the Federal Labor Relations Authority in the past. I would have that list, and I would be ready to make those kinds of proposals to my agency counterpart at the proper time. So that's okay.
Hey, 5 seconds. Just wanted to say that this is only possible because of our donors. If you want to see more of this, then consider donating yourself at tvlr.fm/donate.
Right. Yeah. No. And that was some of the suggestions in that book that I was reading. And it's all like you said, it's all very important. And any step that you can take to kind of mitigating the disaster of having plumtricians, I think should.
Okay, there you go, plumtricians. I couldn't remember what you said.
Yeah, but it's just it was bonkers to me that we couldn't just say you shouldn't do this. Actually, you should just straight up not do it. That's but nevertheless it is what it is, I suppose. So could you go into maybe a little bit more detail or is as far as the scope of bargaining? So, you talked about some of the things that can be bargained over in the private sector, but can't be in the federal sector. And particularly one of the things that you can bargain over in the federal sector is working conditions. So could you give us a working definition for working conditions? What does that mean, and how do I know that okay, this is something that you're doing that I can bargain over? What are working conditions under the statute?
Yeah, well, there's a definition there which I think is useful, and I'll see if I can pull it up. The term of art, which uses working conditions as part of the definition, is conditions of employment, and conditions of employment are pretty broad, and so that's why I would say don't overlook the ability to be meaningfully influential in having these kind of discussions. But there is, beyond what the statute says, and I think I'll read it to you, but I don't think it is particularly means performing. It's conditions of employment means personnel policies, practice, matters, whether established by rule, regulation, or otherwise, affecting working conditions. And again, working conditions for me are anything that affect an individual employee's work life. I mean, that's not saying much. So, for example, overtime. In many work situations, the way overtime opportunities become a big consideration. How is that going to be applied and administered? That certainly is a working condition and a common one that needs to be addressed in negotiations. So a union has an interest, and we say these in words, with a lot of different things there. They want procedures for how it's going to be used. They want to make sure it's applied and offered in a fair and equitable manner, and uniformly. And situations like even performance appraisals and ratings, and particularly when they're used for promotion advancement into other positions. The same thing. Those are working conditions, often comes up in the federal sector. You want to know how those are going to be applied. You want them the same thing. You want to make sure that they're uniformly applied in a fair and equitable manner, and certainly between and among all people in similar job classifications, at least, which often doesn't happen. And you want to thrash that out with the agency to make sure you avoid problems down the road. So those are just a couple of matters. And again, I would try to get the agency's agreement on those kinds of matters and procedures most of the time on those kind of issues in writing and in as detailed a fashion as you can work through and work out.
Right. One of the things that I would like to see when we renegotiate my collective bargaining with the agency would be like a paid lunch break and compensation for travel when we are not teleworking. So I have a 15-minute commute. Other people have a much longer commute, but I think 15 minutes is probably something near the median. So are those things that could be negotiated into a contract, a paid lunch and a 15-minute both ways, 30-minute total commute, being paid for the commute? Is that something that could be done?
It depends on how the context, arises, I guess I would say. And I guess in today's world, travel, in particular, may be an issue because so many workplaces generally, but federal sector workplaces, of course, are going to alternative work schedules and a lot of remote schedules with requirements of coming into the office. So again, I think the answer is that they can, and hopefully the agency would be willing to do that. But what would their defenses might be? Well, in this case, probably the biggest exception that's raised as a practical matter in the federal sector is the de minimis standard. And they might say, is this, whatever wants to be done is de minimis. Well, there's no bright line test on that. And there have been efforts to make that more stringent or not. Probably the biggest defense to requests for bargaining are what's under the law known as covered by defense. My guess in your situation is you're looking to initiate discussions over these concepts, and there's probably not going to be anything in your existing term agreement if you have one. So, and that's another complication. So I would try to tailor those proposals as best I can to characterizations that really are, in a practical sense, beneficial, if you will, for the why does this help the employee as well as the agency do his or her job better? Why is this connected to the agency's mission and the performance not only of the agency itself, but the performance of the individual workers as part of promoting and advancing that? So try to be as specific as you can, connecting it to the agency and its performance, and not just make it sound like, if you will, a nice little benefit for, the individual workers, if you know what I mean.
Mm-hmm. And so thinking about...
So couching and...
Right. Yeah. And so thinking about federal employees who are not unionized yet, who are interested in unionizing, what how similar does that process look to unionization in the private sector? And, one of the things that we've seen the NLRB, for instance, really try to make strides towards is expediting union elections. I think they have cut in half the amount of time that it's taken on average to get from petition filing to election occurring under Abruzzo's leadership. How similar are those processes in the federal sector to the private sector, and how quickly, how quickly could the FLRA make an election happen in the federal sector?
So I would say that the similarities are greater than the differences, and representation matters generally, and specifically in the context of a situation where you don't have representation and the possibility of an election is there. Those are always high priorities by any responsible agency personnel and leadership team who believe in the statute, the agency, and its mission. I mean, matters should be representation matters should always be expedited, and I would say, based on my experience for the most of the time that I was there, that falls within our Office of General Counsel, our regional offices and regional directors, initially oversee it, and expediting, if you will, the possibilities for elections is always a high priority. As you may know, one difference, though, between the two sectors is that in the private sector with the NLRB, one issue that's been debated over the years in an attempt to, if you will, expedite representation has been card check, authorization card check certifications as well. The federal sector does not allow for that. They do require a secret ballot election. So it only puts emphasis on the point that you're making and the question you're asking is as to how important it is to expedite. And I think, again, with rare exception, I don't have any data. I don't, and I've been away from the FLRA for a few months, but I know that representation matters are always among the matters given the highest priority within the agency's responsibilities.
And so you spoke to the FLRA's prioritization briefly there, that election matters, representation matters are considered pretty highly. Whenever other cases come before the FLRA, how does the FLRA prioritize other cases? Is it kind of like representation first, and then collective bargaining second, and then grievances third, or what's kind of the general rule of thumb for the FLRA as they decide what cases to take up?
So I'd say a couple of things. First, like the NLRB, just for your listening audience to clarify, representation matters and unfair labor practice matters are very similar, identical to the way the NLRB handles it. But we also have negotiability disputes, which is a unique category of cases unique to the federal sector, or the public sector at least. And then we also handle appeals from grievance arbitration awards. We sit as a surrogate for the federal courts in the private sector to handle any appeals, if you will, or exceptions taken from arbitration awards. And that's a huge category of cases in the federal sector. Representation matters are always the highest priority, and there's a statutory deadline for us to try to expedite and move those, as well as within our own regs. But I would say over time, the way other cases are prioritized really depends on the current leadership teams, members like myself and who were there. Why do I say that? Well, for example, when I came into the FLRA initially in 2009, unfortunately, we had a huge backlog of cases, and we needed to get rid of it, and we strove to do that. So one of the discussions was, do we try to get rid of our older cases first Or how do we deal with cases that are coming in right now every day? And we tried to come up with a blend of that. We didn't want to ignore the matters that were coming in fresh, simply at the expense of getting rid of the backlog. So we tried to harmonize it. We came up with a plan, and we actually submitted it to case reduction backlog plan. We submitted it to Congress and OPM, where we tried to blend it together, and we used the resources of staff. We certainly were looking to whittle down, going back to our oldest cases that were part of the backlog, and get rid of them little by little, while also doing a percentage of the cases coming in fresh. And we did get rid of the entire backlog within, I can't remember how long, about a year and a half. But different members are going to have different perspectives and vary, I'm sorry to say. And so there's beyond that no rhyme or reason.
Right. And so, I think this would be a good place to wrap up with as it relates to the makeup of the FLRA. With your not being reconfirmed, there is an empty seat on the authority. The general counsel's office is also vacant. And this is the body that's responsible for administering federal labor law. So what does that mean for workers like me, or just rank and file workers in the federal government, union officers in the federal government, even potentially management in the federal government, that we have an empty seat on the FLRA and the general counsel office being vacant?
Yeah, I would say the impact and the considerations and the concerns are huge. And anyone who cares about the federal sector, as I do, who believe in the virtues, even the nobility, I would say, not to exaggerate, of public service, working for the public service, should be very concerned. And what I would say is one distinction that I've made, and I've been in this business a very long time, since Jake, with all, God bless you, since long before you were born, even. I have almost 50 years of labor management relations experience, worked at all three federal agencies, was in a leadership position at one of the other agencies as well. It was a privilege. But I would say that, a lot of people, the average person, to the extent they care about nominations by presidents and confirmation by the Senate, they think about the Supreme Court, and maybe they think about judges, and they overlook the impact of people appointed to various agencies. And if you're in the labor management relations world, and again, the federal agency is one of three agencies overseeing only one of three laws, the impact of not having people like myself, and it's not about me, but not having a full complement of members. And one of the main things we do is sit in a quasi-judicial capacity. Not having a general counsel who, like the NLRB, is one half, if you will, of the agency, with the ability not only to handle representation matters, we just talked about elections, but also to investigate and decide whether or not to issue unfair labor practice complaints. You keep that position vacant, you're really neutralizing the agency. And what I would say over time to people is this, and this is what I've said. In my entire professional life, I've seen instances where you have disagreements, let's say, between labor unions and management. And those are understood and acceptable. In the business of labor management relations, there's an understandable arena where you come to expect that. And that was often reflected over past decades by the nature of appointees you might get, say, from Republican presidents as opposed to Democratic presidents. Now, I'm afraid what you have to look at is this just a labor management issue, or is this really just an attempt to destroy the agency? is this just a reflection of the fact you don't believe in this statute? You don't believe in that mission. And I think that's what you have to look at. And to me, that's really a shame, but that's worth fighting over, quite frankly, and working hard to defend. So you have to, those who have concerns about that, you need to raise your voices and weigh in with your representatives, whether they be union reps, members of Congress, and certainly the Senate. And I would say the agencies too, because I really believe, as I said, not because it's about being nice or kumbaya, but I believe in most instances that agency reps, agency management, and unions who are exclusive reps of federal employees should have more of a joint desire to address issues that they're both interested in, to enhance the performance of the agency, to provide the service to the public in a more effective and efficient way. And I know sometimes when you have requests for bargaining, you say, oh, what a waste of time and it's a nuisance. Sometimes it feels that way. I know that very well. But I think in the long term, it's beneficial to workers, management, and unions to sit down and do it. So by rendering the agency unable to fulfill its functions effectively by not getting members and general counsels confirmed, that's a serious matter. And hopefully people will raise their voices to try to make it happen.
Right. Ernie DuBester, former chair of the Federal Labor Relations Authority, really appreciate your time this morning.
Well, I was happy to be here. All the best to you and your listening audience.
Thank you. All right, folks. Like I said, that was Ernie DuBester, former chair of the Federal Labor Relations Authority, appointed 3 times by 3 presidents to the agency, and apparently has served in all 3 incapacities, administering all 3 of the large labor relations laws in the country: the RLA, the NLRA, and the federal statute. I did not realize that. So really appreciate his time, and maybe look forward to getting him on again. You just saw a clip from the Valley Labor Report. We are live every Saturday morning from 9:30 a.m. till 12:30 p.m. And we pride ourselves on keeping all of our content free to everybody so that we can talk to as many working folks as possible. If you support the work that we're doing, you think that it's important, you think that it's good, then consider making a monthly contribution to the project, and you can do that on our website, tvlr.fm.